Article 1, Section 8 of the Constitution states that Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. This clause established what we know today as copyright. Copyright encompasses what is often referred to as a bundle of rights. This bundle does the job of balancing the rights of creators and users of works. These rights reward creativity by allowing creators to protect and monetize their work, but only for a limited period of time. But what exactly are these rights? Copyright owners have the right to reproduce a work in copies or phonorecords, create derivative works, distribute copies by sale, transfer of ownership, lease, or lending, and perform or display a work publicly. Copyright specifically provides protection to original fixed works. A work is considered fixed when it takes a tangible form of expression, and a work is considered original when it is created by a human and has a minimal degree of creativity. Copyright law recognizes many types of work, including paintings, photographs, musical compositions, sound recordings, books, movies, plays, blog posts, and much more. Many people think of copyright like a patent and believe works must be registered in order to be protected. However, with copyright, a work meeting the proper criteria is protected as soon as it's created. This means that something as simple as a doodle on a napkin or an original poem written on the back of a receipt is protected by copyright. Of course, not all works are protected by copyright. Facts, ideas, or utility-based items like t-shirts or forks are not protected, though the decorations on them may be. Neither are works in the public domain, which includes all works published by the US federal government. Let's take a look at a real case that helps establish what kind of works can and cannot be protected by copyright. Rural Telephone Services Company, a public utility company providing telephone service to communities in northwest Kansas, issued a telephone directory that featured an alphabetical list of subscriber names and telephone numbers. Meanwhile, Feist Publications, a publishing company specializing in telephone directories for larger geographic areas, was in the process of compiling their own directory. Feist reached out to 11 Northwest Kansas telephone companies, including Rural, and offered to pay for the rights to license their listings. Of the 11 companies, only Rural refused. Feist decided to go ahead and use Rural's listings without permission, and Rural then sued for copyright infringement. Now, it is entirely possible that Feist could have done the work of collecting telephone numbers themselves, so how did Rural know the listings were copied? Because the Feist publication included fake listings that Rural had included in their own directory in order to detect theft. It turns out that all of those fake entries were useless though, because the court ruled that Feist did not commit copyright infringement. This case asserted that facts, such as phone book listings, are not creative and therefore are not protected by copyright. With the Feist and Rural case, we are looking at two corporations as opposed to an individual person. This begs the question, who owns the copyright for a work? In many cases, the creator of a work is the owner of the copyright. If a work has multiple creators with indistinguishable contributions in the finished work, all of them are equal copyright owners. In some instances, however, a work may be created under the scope of employment, and the employer is considered the copyright owner. This is commonly known as a work for hire. Ownership may also be transferred by being sold or licensed. We must also remember that copyright does not protect a work forever. These rights do not exist solely to benefit creators. Part of the balance that copyright seeks to maintain is users' rights. The duration of protection varies depending on when a work was created. Currently, any work created after January 1st, 1979 maintains copyright protection for the life of the author plus 70 years. Copyright law has changed over time, particularly in response to new technologies. It's also heavily determined by case law, meaning that how protections and exceptions are interpreted by a judge on a particular case can change how the law is actualized and influence future decisions. This is something to keep in mind as new technologies like AI continue to grow and are called into question in relation to copyright. The Copyright Act of 1976 was a response to new technological innovations, including cable television as well as computer, sound, and video recordings. This act was designed to make the law more adaptable to new and emerging formats. Prior to this act, protection of individual formats or mediums had been added to copyright law. For example, the Townsend Amendment of 1912 provided copyright protection to motion pictures. Before this amendment, copyright owners registered movies as still photographs, submitting paper copies rather than film to the U.S. Copyright Office. So far, we've mostly covered how copyright applies to creators or owners of copyright, but what about those of us who are interested in using copyrighted works? Technically, we use copyright-protected works every time we view art, read a book, watch a movie, or listen to music. But sometimes we may want to use a work in a way that is protected by copyright law. There are a couple of ways we can do this. In the next video, we'll take a look at an exception to copyright known as fair use, as well as Creative Commons and the public domain. Want some help? Schedule a research appointment with one of our librarians today.